Dorothy was 81. She had owned her Sarasota home for 28 years. Outright, no mortgage, payoff loan the dough. Worth $310,000. It was her retirement, her security, the thing she planned to leave to her children. One afternoon, the woman who'd been helping her with errands brought some papers to sign. Dorothy trusted her. She signed them. She didn't have her reading glasses. She didn't call her daughter. She did not know what she was signing. 6 months later, Dorothy's daughter flew in from Atlanta, noticed a tax notice addressed to someone else's name, looked up the Sarasota County property records, and found that her mother's home had been transferred. There was a $180,000 loan against it. Dorothy had no memory of signing anything about her house. Here's what happened next. And here's the Florida law that got Dorothy's home back. Dorothy had lived in that Sarasota home for nearly 3 decades. She raised her children there, paid off the mortgage, and watched the neighborhood change around her. Her 2 adult kids, one in Atlanta, one in Tampa, checked in regularly, but weren't present day to day. About 8 months before the story begins, a woman named Priscilla, the girlfriend of Dorothy's grandson, had started helping with errands, doctor's appointments, grocery runs, paperwork. Dorothy was grateful. She had moderate cognitive decline that hadn't yet been formally diagnosed, but it was there. The confusion that comes in waves, the forgetting, the trusting too easily because processing is harder than it used to be. Priscilla built that trust deliberately and patiently over months. She knew Dorothy lived alone. She knew the home was mortgage-free. She knew the property records were public. She had a plan. Priscilla arrived one afternoon with a stack of documents. She told Dorothy they were related to her Medicare supplemental insurance, forms that needed updating. Standard stuff, she said. Nothing to worry about. Dorothy didn't have her reading glasses. She didn't read what she was signing. She didn't call her daughter or her attorney or anyone who might have looked at what Priscilla had actually placed in front of her. She signed. What Dorothy signed was a quitclaim deed. It transferred her $310,000. Sarasota home, owned free and clear, her primary asset, to Priscilla. Within 48 hours, Priscilla had recorded the deed with the Sarasota County Clerk of Courts. The recording was valid on its face. The property records now showed Priscilla as owner. 2 weeks later, Priscilla used the property as collateral for a home equity line of credit. She received $180,000. Dorothy knew nothing about any of it. The daughter's visit was supposed to be routine. A long weekend. Catch up. Check on mom. Then she saw the tax notice on the kitchen counter, addressed to Priscilla. She opened her laptop and pulled up the Sarasota County Property Appraiser's website, a free, publicly accessible database that shows current ownership for every property in the county. The title to her mother's home had changed. Her mother's name was gone. She sat with Dorothy carefully and asked what she remembered about signing anything about the house. Dorothy remembered some papers that Priscilla said were Medicare forms. She had no memory of a deed, no memory of transferring her home. When she began to understand what was being explained to her, she was afraid. The daughter called an attorney that night. The attorney asked 2 questions first. When did the deed record, and does the property have a mortgage on it now? Both answers were worse than expected. Florida's attorney recognized the situation immediately and explained that the law had already built 2 separate response frameworks for exactly this. The first is criminal Florida Statute S-825.103, which makes it a felony to obtain or use an elderly person's funds, assets, or property by deception, intimidation, or undue influence. The statute doesn't require the elderly person to have been declared legally incompetent. It requires only that the perpetrator obtain the asset through means the person would not have consented to have they fully understood what was happening. Presenting a property deed as Medicare paperwork to a cognitively impaired 81-year-old, then recording it and obtaining a $180,000 loan against the property, that's deception. And the $310,000 home value placed this firmly in first-degree felony territory under S-State 125.103. The second framework is civil. Florida Statute SS 415.1111, which gives vulnerable adult exploitation victims the right to sue, void fraudulent transactions, and recover actual damages, punitive damages, and attorney fees. Both tracks started moving simultaneously. The attorney filed a police report with the Sarasota County Sheriff's Office and a complaint with Florida Adult Protective Services under SS 415.1055. APS has independent investigative authority over vulnerable adult exploitation. They can open a parallel investigation alongside law enforcement, interview witnesses, pull records, and coordinate with the state attorney's office. The Sarasota County State Attorney's Office has a dedicated elder abuse unit, and this case went straight to them. The elements stacked clearly. Dorothy was 81, well above the 60-year threshold that defines elderly person under the statute. Priscilla had a caregiver relationship with Dorothy, as defined by Chapter 825. She obtained the property by deception, misrepresenting a quitclaim deed as Medicare forms. The asset value, a $310,000 home, plus $180,000 HELOC, put the exploitation squarely in first-degree felony range. The criminal investigation began. Simultaneously, the civil case moved through the Sarasota County Circuit Court, the 12th Judicial Circuit. The quiet title action, the specific legal proceeding used to void a fraudulent deed and restore the original owner's title, was filed citing two independent grounds. First, Dorothy's lack of mental capacity at the time of citing. Florida law requires a grantor to possess sufficient mental capacity to understand the nature and consequences of a property transfer at the moment of execution. Dorothy's treating physician provided a declaration that her documented cognitive decline, consistent with what he had observed in appointments during that period, was sufficient to establish she could not have understood what she was signing. Second, Priscilla had procured the deed through undue influence and deception, a recognized and independently sufficient ground for voiding a deed under Florida equity law. Both grounds gave the court clear authority to void the deed entirely. There was a third legal target, the lender who had issued the $180,000 home equity line of credit. The attorney argued that the lender had failed to conduct adequate due diligence when accepting a recently transferred quitclaim deed as immediate collateral from a first-time borrower. This is a recognized red flag in standard mortgage lending practice. A borrower presenting a property that had been quitclaim transferred to them just weeks earlier and immediately seeking to borrow against it should trigger inquiry. A basic investigation, a title search, a conversation with the previous owner of record would have revealed the suspicious circumstances of the transfer. The lender's failure to make that inquiry when a circumstance demanded it exposed them to a negligent lending claim. Faced with that exposure and the evidence of the fraudulent deed, the lender settled. The $180,000 claim against Dorothy's property was discharged as part of that settlement. The debt did not survive the deal. Discovery in the civil case produced exactly what the attorney expected. Phone records showed communication between Priscilla and Dorothy in the days leading up to the signing. Priscilla's own bank records documented the $180,000 HELOC disbursement and how the funds were used in the weeks following. The grandson provided testimony about the nature of Priscilla's relationship with Dorothy, how access had been gained, how the dependency had developed, the conversations that had taken place about the property. Dorothy's medical records, subpoenaed from her physicians, showed the progression of her cognitive decline in the months surrounding the signing, consistent with someone who could not have understood a legal property transfer even if she had read every word. The physician's declaration turned from supporting evidence into the cornerstone of the court's capacity finding. Priscilla's attorney attempted to argue the execution had been valid. The court was not persuaded. The Sarasota County Circuit Court voided the quitclaim deed. Dorothy's title was legally restored. The lender's $180,000 claim against the property was discharged as part of the civil settlement. On the criminal side, Priscilla was convicted under Florida Statute S. 825.103 and sentenced to 6 months of probation with court-ordered restitution under SS 775.089. Mandatory in Florida criminal cases involving victim loss, covering the legal fees and costs Dorothy's family had incurred. The home, all $310,000 of it, came back to Dorothy. No litigation fees remained, no HELOC hung over the property. The deed that Priscilla had recorded within 48 hours of the signing was gone from the public record, replaced by Dorothy's restored title. A case that had looked devastating when the daughter first opened that laptop became through the application of two Florida statutes working together, something that could be fully undone. Every Florida family with an aging parent needs to hear this clearly. If you discover that a loved one has transferred property or signed any document with legal consequences to someone they depend on without telling family, without involving an attorney, without clear recollection of what they signed, treat it as a legal emergency, not a delicate family matter, not something to handle quietly to protect anyone's feelings. An emergency. The moment you find an unexplained deed transfer in a county property record, the clock starts running on the statute of limitations, on the evidence that might disappear, on the funds that might be spent. Call an attorney and report it to law enforcement simultaneously. The two tracks, criminal under S. 825.103, civil under SS 415.1111, reinforce each other. What law enforcement discovers goes into the civil case. What civil discovery reveals supports the criminal prosecution. They are designed to work together. Here is the specific action this episode requires. Go to your county's property appraiser website right now. Search your elderly parent's name, look at the ownership record. If the name on the record is not theirs, or if there's a name on there you don't recognize, that is the conversation you need to have tonight with an attorney and with law enforcement. Many Florida counties also offer deed fraud alert programs, free email or text notification services that alert you when any document is recorded against a specific property. Enrollment takes 2 minutes. It costs nothing. It may be the only warning system standing between your parents' home and a fraudulent deed recorded while they didn't know what they were signing. The Sarasota County Property Appraiser's website is free. The APS hotline 1-800-96-ABUSE is free. The Florida Bar Lawyer Referral Service to find an elder law attorney, free. The protection costs nothing but the knowledge of where to look. The most powerful version of this protection is the one you put in place before the crisis. A properly executed durable power of attorney designates a trusted family member to handle legal and financial matters on behalf of an aging parent, eliminating the need for an elderly person to sign anything on their own when a caregiver shows up with a stack of papers. Irrevocable living trust, properly funded with the home as an asset, means the property cannot be transferred by quitclaim deed without trustee authorization. And a formal cognitive assessment, AMMSE, or MOCA administered by a physician, establishes a documented record of capacity at a specific point in time, which becomes critical evidence if a transfer is ever challenged. These are non-expensive or complicated steps. They are the steps that make Dorothy's situation something that never gets started, rather than something that has to be reversed in court. 2 things tonight. First, call the elderly person in your life who has a home in Florida and ask if anyone has brought them documents to sign recently. Not accusatory, just checking in. Second, go to their county property appraiser's website and look up their address. See whose name is on the ownership record. It takes 60 seconds. If the name is wrong, you are no longer in prevention mode. You are in the legal emergency mode that Dorothy's daughter found herself in. And now you know exactly what Florida law gives you to respond with. S. 815.103 for the criminal track. SS 415.1111 for the civil track. The quiet title action to void the deed. The APS investigation running parallel. The lender liability if a loan was placed against the property. Dorothy got her home back because her daughter found out in time, and because an attorney knew what to do when she did. Now, so do you. 181-year-old woman, 1 quitclaim deed, 1 caregiver who thought Dorothy wouldn't remember signing. Not because she was clever, because she knew Dorothy was alone, trusted, and declining. Dorothy's daughter found out in time, the law was waiting, and her home came back. That knowledge is power, and power should never be kept secret. If this episode made you want to call a parent or grandparent tonight, hit like, share it with every family with an aging parent who owns a home in Florida, and subscribe if you haven't already. New episodes drop every week. Real law, real stakes, real people. Until next time, stay informed, stay protected, and never let them take what isn't theirs. This has been State Law Exposed.